case briefs, and so much more. LSData's got what you're looking for.
The story begins in 1978 with the Supreme Court case, Regents of the University of California v. Bakke. The crux of the issue centered on whether it was constitutionally permissible under the 14th Amendment's Equal Protection Clause for a public university to consider race as a factor in its admissions process without resorting to a race-based quota. The controversy arose from the admissions program of UC Davis Med School, which reserved 16 out of 100 places for minority students. A white applicant, Allen Bakke, who was rejected even though there were applicants admitted under the program with lower scores, challenged the validity of the program. The California court ruled in Bakke's favor, deeming the special admissions program unlawful as it violated equal protection principles and prohibited the future use of race in admissions decisions. However, they did not order Bakke's admission to the university. Bakke appealed this decision, leading the case to the Supreme Court. The Supreme Court of California upheld the judgment against the program, but issued a directive for the trial court to admit Bakke. A divided Supreme Court agreed with the lower court's decision that the program was unlawful, and they concurred with the California court's directive for Bakke's admission into UC Davis Med School. However, they disagreed with the injunctive ban on considering race in admissions altogether. Justice Powell, in his examination of Title VI of the Civil Rights Act of 1964, which outlaws race-based exclusion from federally funded programs, argued that the white majority is not homogeneous and is made up of varied minority groups. Thus, he cautioned that any preferential treatment could inadvertently reinforce stereotypes. He further remarked on the importance of diversity in education, dubbing it a compelling interest. In conclusion, while race could indeed be a factor in the admissions process, it should not be the defining factor, thereby settling the constitutionality of considering race in admission decisions without resorting to a quota system.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class behind.